On September 1st, the Standing Committee of the National People's Congress passed the Foreign State Immunity Law. This law is extremely important, but perhaps the legal issues are too professional, and the threshold for official interpretation and understanding is relatively high. Let's try to chat. In the current situation, communication between major countries is necessary, which is very important, but from a pragmatic point of view, communication alone cannot change many things, and in the end we must rely on strength to speak. In the face of more intense future games, we must make more adequate preparations. This preparation is real economic and military power, and even legal weapons. Of course, countries rely on strength, but human beings are still a civilized world after all. Small countries can be arrogant and violently subjugated, but countries of the same level, especially the world's top nuclear powers, will not easily go to the last step. Even if the whole world knows that NATO has reached the extreme level of support in addition to directly integrating the system into the war, but as long as the last window paper is not torn, it will still be a conflict between Russia and Ukraine. In this case, we must be prepared for everything. The Foreign State Immunity Law mentioned at the beginning is extremely important. This law seems to emphasize that foreign countries and their properties enjoy immunity from jurisdiction in the courts of the People's Republic of China, the first half of Article 3, but it must be combined with China's with regard to the consistent attitude on foreign state immunity. The real focus is except as otherwise provided for in this law, the second half of the third sentence. To put it bluntly, it clarifies the special circumstances under which foreign countries and their property do not enjoy jurisdictional immunity, that is to say, they can become defendants in Chinese courts. It's not writing a thesis, so I won't say much about the historical evolution of state immunity. Those who are interested can check the papers by themselves and say that everyone is interested. Note that foreign state immunity has always been a key bargaining chip in the game between countries. The more intense the game, the more it is used, and it is extremely easy to use. Since the United States passed the Foreign Sovereign Immunities Act in the 1950s, it has been used as an important tool to maintain or snatch interests from the outside world. For example, terrorism. After the Cold War, terrorist attacks in the United States became more and more rampant. Therefore, a terrorist exception was added to the Foreign Sovereign Immunity Act, allowing victims of terrorism and their families to use domestic laws to prosecute countries that sponsor terrorism. This design is good in theory, but since the right to identify terrorism was weaponized later, as long as you are not obedient, it is terrorism. No matter how cruel crimes against humanity are committed by obedient people, it is not terrorism, which is chaotic. Coming. For example, taking advantage of the general election in 1996 and 2016, the United States revised the Foreign Sovereign Immunities Act, canceling the state immunity of Cuba and Saudi Arabia. It is still going on now, because once the law is established, it is not easy to amend it even if another party comes to power, which makes these two countries very passive. Of course, these two countries are not the only ones who have suffered this treatment. For example, according to the principle of terrorism exception, countries such as Iran that have been included in the list of state sponsors of terrorism have also suffered a large number of lawsuits. Lawful way to deprive Iran of overseas assets and put a cloak of civilization on the robbery. Countries such as Cuba and Iran did not sit still, and also passed legislation to deprive the United States of its national immunity. For example, Iran specifically deprived the United States of its national immunity in 2000, while Cuba deprived the United States of its immunity in 1996. After the United States and Cuba resumed diplomatic relations in 2015, when discussing the state immunity of the two countries, the United States filed a huge claim against the Cuban government in order to exert pressure, and Cuba also filed a claim of $300 billion against the United States based on domestic legislation. The two countries have hedged against each other on this issue. Back to China. Let me talk about a conclusion first. China can be regarded as a global model in terms of foreign country immunity. It never talks about double standards. It restricts itself as much as it demands from the other party. This is fair. For example, China has always insisted that any country is absolutely exempted, but all state-owned enterprises do not enjoy immunity. It is reasonable to say that China has a large proportion of state-owned enterprises, but China has never supported Chinese state-owned enterprises to enjoy immunity. It always believes that state-owned enterprises are independent legal persons. Since they participate in market competition and global competition, they must of course assume obligations while enjoying rights. For example, in the China Aviation Oil case in 2005, China Aviation Oil filed an application for state immunity in the Singapore court, but the Chinese government not only did not support it, but also required China Aviation Oil to resolve it in accordance with international practice and China's consistent attitude. Another example is the China Coal case in 2017. China Coal also proposed an exemption. The government not only did not support it, but also publicly stated that China Coal does not enjoy special status or benefits. Of course, this is also a very rational choice. China's biggest competitive advantage is market competition. As long as it is a fair market competition, we are not afraid even if some countries take sides. There is no need to break the rules that are beneficial to us. Enterprises go out to restrict, so as not to tarnish the country's image, so as not to provide some forces with targets to attack China. I won't expand much on state-owned enterprises, and the focus is still on the state. Since the founding of New China, we have always insisted that any country enjoys absolute immunity and cannot become a defendant in the courts of other countries. This is related to our consistent diplomatic stance and the international environment at that time. The international environment after the founding of New China was much worse than it is now. There are too many, and the sanctions received in many fields exceed that of the Soviet Union. In response to the endless stream of foreign governments listing China as a defendant in their own courts, China first emphasized that all countries enjoy absolute immunity, which is like promising not to use nuclear weapons first, and for those who do not grant China immunity but also forcibly prosecute China, it is also retaliation will be taken accordingly. There are many examples, the key names are listed, and you can search by yourself, so I won't go into details. In 1952, the two airline companies case with the United Kingdom. The Horse brand fireworks bombing case in 1979. There are also the Tianyu case in 2006 after China's entry into the WTO, the Beijing New Building Materials case in 2016, and so on. Before 2020, on the issue of state immunity, countries around the world still respect China's absolute right to immunity. But things have changed in 2020. This year, the COVID-19 outbreak broke out. I believe some people still remember the international public opinion battle at that time. There were a large number of lawsuits against China in the United States against China. Not only that, but in some parts of the world, the phenomenon of using immunity as a weapon has also appeared. The typical examples are Russia and Ukraine. The result is obvious, and the other party's assets are enforced according to the trial results. Now that the situation has changed, it is obviously impossible to talk about repaying grievances for virtue, so it is necessary to clarify the right of state immunity through legislation. The most important thing is to clarify the circumstances under which other countries do not enjoy immunity. This can also be understood as deterrence. Although the big power game still has a bottom line and a tacit understanding, it will not cause irreversible troubles, but the closer the strength is, the more intense the game will be, and it will definitely exert extreme pressure. It is inevitable to create bargaining chips for negotiation and pressure out of thin air, and we also be prepared for what to do if the opponent really threatens to freeze or confiscate property. It is impossible to make legislation at that time. It must be noted that doing so is fully in line with international law and practice. The specific exception clauses are not listed one by one. See Articles 4 to 15 of the law. Only two very interesting ones are singled out. Article 9 for compensation lawsuits arising from personal injury, death, or loss of movable or immovable property caused by relevant acts of a foreign country within the territory of the People's Republic of China. The courts of the foreign country in the People's Republic of China do not enjoy jurisdictional immunity. Article 19. The courts of the People's Republic of China shall accept the certification documents issued by the Ministry of Foreign Affairs of the People's Republic of China on the following factual issues related to state behavior. 1. Whether the relevant country in the case constitutes the foreign sovereign states. With regard to Article 19, whether certain countries or some regions claiming to be countries are countries and whether they enjoy immunity are determined by the Ministry of Foreign Affairs.